In previous lessons, we've been talking about various different ways and methods of offering a contract, offering to contract, should I say, versus the acceptance of an offer. This lesson is going to focus on this in more detail and talk about the communication of acceptance, how acceptance has to be communicated to the offeror in order for a contract to have any kind of validity. We took a brief overview in the last lesson of the postal rule for acceptance of an offer, describing the fact that even if the acceptance of the offer hasn't officially returned to the recipient, hasn't returned to the recipient and hasn't returned to the original offerer, this does not mean that therefore negates any kind of acceptance, because the postal rule says that if you're accepting by way of post, as soon as it enters into the Royal Mail, as soon as it enters into the postal service, that is representative of an acceptance. Now, we noted in earlier lessons that this is something of an outdated method for acceptance, given that in today's context, acceptance takes a number of different forms, and most people probably don't take acceptance by way of the postal method anymore. And even if they did, the postal rule is a little bit more negated, given the fact that the Royal Mail and the postal services in the United Kingdom are far better than they were back when the postal rule was originally established. No longer does it take 4 or 5 days for a letter to go from one part of the country to another. Today it takes about a day, depending on how much you're willing to pay for postage. So as a result of this, there are other things that we can think about in terms of communicating and making sure that your acceptance of an offer is communicated back to the offeror. As we've explained in previous lessons, unless acceptance is communicated to the offeror, there cannot be a valid contract. So if acceptance is not communicated, there cannot be a valid contract. There are general exceptions to this rule. So, for example, the use or suggesting that acceptance could be inferred through the conduct of the parties. That is an exception to this rule, because in those cases there is not an official communication of acceptance back to the offeror, but a valid contract has still been suggested to exist, owing to the fact that they have performed the obligations of the contract, and therefore inferring that they have accepted those obligations. Now, the principle that acceptance has to be communicated was established in the 1955 case of Entores versus the Miles Far East Corporation. Now, in this case, we have the claimants who were in London, and they had made an offer to contract by teletext, or telex, shall I say. This is a very early electronic communication method. Of course, telex isn't used anymore, just like fax machines aren't used anymore. Some of you who are maybe in your first year of university probably don't even know what a fax machine is. And so as a result of this, this is a very an old and antiquated method of communication, but it still enshrines and underlies a very important principle within contracts. The defendants were in a different jurisdiction. They were in Amsterdam, in the Netherlands, and they had accepted the offer. Now, the issue of this case was around the question of jurisdiction, because when the claimant sued for the breach of contract in the English court, the matter of whether or not the English High Court had jurisdiction was the question for this case. Now, they would only have jurisdiction if the contract was formed in the United Kingdom, okay? And not if it was formed in Amsterdam. So what do we really have here? So if we think about this communication, you have an offer going from London all the way to Amsterdam, and then you have an acceptance of that offer going from Amsterdam back to London. So if the acceptance of the offer validates the contract at the point at which it was accepted, it would have been accepted in Amsterdam, and so as a result of which the English High Court would not have jurisdiction, because therefore the contract would have been created in Amsterdam when it was accepted. But if, as spoiler alert, it was the case in this example, it was found that the communication of the offer validates the contract, then that means that the contract wasn't formed in Amsterdam when the people in Amsterdam decided to accept it. It was formed when the original offerers had received communication of that acceptance, which means it was communicated back to London, therefore validating and creating a contract under the jurisdiction of England and Wales, therefore giving the English High Court jurisdiction. So and that's what happened essentially. The High Court did have jurisdiction owing to the fact that the formation of the contract, the point at which a contract exists, was when that acceptance is communicated. And it gets communicated when the communication is received back by telex to London, and therefore in London was it communicated. It does not create a contract is not created when the acceptance is merely decided all the way back in Amsterdam. So, since it was held that this case was the case because the contract was formed when the acceptance was communicated. So there you go. That is the explanation of how communication of acceptance essentially operates. Now, there are some various exceptions and various different stipulations that we can think about here. One example is whether or not silence could ever represent the acceptance of an offer. If I'm an offeror and I decide I want to make a contract with somebody and I send an offer out to them, does getting no response ever constitute acceptance? Could that ever constitute acceptance? Well, the short answer is no, owing to the fact that from the previous case, the offer has to be communicated. So if you just have a lack of response, then that can't amount to a contract. And the case from 1862 of Feldhaus and Bindley is a good example of this being illustrated. The alleged contract at issue was for the sale of a horse in this case. The claimant had offered to purchase the horse and communicated this offer by letter. As you can probably imagine, in 1862, there was no email. And so they stated in the contract that, quote, if I hear no more about him, I consider the horse, that's supposed to say horse, I'm sorry, I consider the horse mine at whatever price it was, the price that was stipulated. Now, this is quite interesting, because if that's the case, then essentially what this is suggesting here is that if you hear nothing, if you have no response from the person who is communicating the offer, then therefore it is mine. And this is almost like the inverse. So whereas, and almost like it's an assumption of contract. There is an assumption that the contract already exists, and that is only negated if you communicate back to me that there isn't an acceptance of the offer. If you don't communicate back to me, then there is an acceptance of that offer and the contract exists. It is only when you do communicate back to me. It is almost it's almost negative in terms of the way in which it is situating where acceptance lies in this particular case. The defendant in this case was an auctioneer who was told that he had to keep the horse out of sale owing to the fact that the owner was reserving the sale for the horse to a claimant. However, the defendant accidentally sold the horse when instructed otherwise. And so the claimant didn't bring a claim for breach of contract, but instead brought litigation for the tort of conversion. Now, tort of conversion is one of those torts that isn't really taught, T-A-U-G-H-T, anymore in universities, because for the most part, the vast majority of the law of tort is focusing around things like negligence, defamation, occupiers' liability, etc., etc. And so the tort of conversion is sort of pushed to the side and only really ever covered in quite niche and advanced contract law modules or even personal property law areas. But essentially it's an intentional tort, and we can suggest that it is the essentially with intent taking the exercising over the chattel and ownership inconsistent with the real owner's right of possession. That's the sort of general quotation that we describe in England and Wales as being the tort of conversion. You don't need to know in any great detail what the tort of conversion is and how it operates, because essentially we're talking about contracts in this lesson. It was held that there was no such claim for breach of contract if it was ever brought. It wouldn't have been, and it couldn't have been, or even the tort of conversion, owing to the fact that no contract had existed. Because there was no communication of an acceptance, there cannot have been a contract form. So all the subsequent things that happened as a result in this case was irrelevant because there was no contract. So all of the auctioneering and the selling of the horse off to another third party was completely valid, and the individual who was trying to claim for the tort of conversion had no claim and no basis for a claim, because silence cannot represent an acceptance of a contract.